It's very nice to be here, and it's a pleasure to greet everybody who's online. The pandemic left us, but we are still sometimes doing this online stuff, which is good because we get connected with different people from different places that it would be impossible without this pandemic innovation. I'd like to thank very much Professor Emilios Christodoulidis. I know him from a while. It's a long time we haven't seen personally, but it's a pleasure to greet him online. I've heard that he's in Greece, so the weather there must be not so bad as usually for him. I will present very shortly Emilios. Emilios is professor is for jurisprudence at the School of Law at the University of Glasgow. He has been also a visiting professor in many European and universities, but also he has been in Brazil, has been in North America, in Australia. He has lectured in many important universities. He's also a professor at the Helsinki University, the University of Helsinki. He's also author of very well-known books, A Critical Theory of the Law, Reflections on Origin, Trajectories and Conjunctures, and social rights, and he has been writing a lot on social rights constitutionalism. I already a couple of years from now, I have been reading his stuff on social rights constitutionalism and social rights and social and crisis in the European Union and the crisis of constitutionalism. And he has always been a very sharp critic of the legal transformations, economic transformations of world society, especially regarding austerity politics and the capping of the possibilities of constitutionalism. I will not talk too much. I will just give him the floor. Emilios, you have 20 minutes to somehow present a little bit the paper you shared with us, and then a discussion will follow when we're gonna have questions and answers and a debate on your talk. Thank you very much to be here. For being here. It's a pleasure to see you and to greet you, even if it's just online.
Fantastic. Thank you very much, Pablo, and thank you, Edvaldo, for the invitation to be there, even if it's only virtual. I do very much hope to be in maybe Brazil in the following year and meet you in person. And I appreciate this is a little bit of a distraction from the much more important business of electing a president, but we will have it is still very, I hope we have a nice discussion, and I do thank you very much for this opportunity to address you. Now, just a little bit of background. I sent two papers. One is a self-standing paper. The other one is a chapter from a book that I wrote called The Redress of Law. This is a book that I had been writing for 10 years. I mean, I had also done other stuff in the 10 years. I wasn't just writing this book, but it took most of the 10 years to write it. But what I will do, and this book is actually, I should say, the middle part of this book is coming out in Portuguese in January, so it will be available for a Brazilian readership. Now, what I'll do is I'll present some thoughts from the paper. There's an overlap between the paper and the chapter. I wrote the paper first, and then the chapter focuses in on a few things that were more difficult about it, but we can move to the chapter if you want. So let me present the paper relatively briefly. And what I would like to do is identify a few points around. I know in Brazil there is like in much of South America, there is a deep fascination with social rights. And although, as Pablo said, I have also written a lot about the European Constitution and the deformation of European constitutionalism, I will try and avoid references to Europe and stay with the more general discussion about social rights. Okay, a few key things, just going through the paper. There is quite an abstract discussion that has caused a lot of upset, which has to do with the idea of the dogmatic. Now, this is not my idea. It is an idea that comes from two French theorists, Pierre Legendre and Alain Soupiot. Alain Soupiot is the foremost labor lawyer in France. And they suggest, especially in a discussion about dignity, they suggest that dignity should be understood as a dogmatic value. And what they mean as and I try and do the same thing with solidarity. So my main argument in the paper is that solidarity is a dogmatic value. And dogmatic, of course, has strange connotations, sometimes connotations that we want to resist, that this is something we take on faith, yeah, like dogma. But my own emphasis is on this unquestionability. So dogmatic is something that is unquestionable because it is axiomatic. It is the point from which you start. And what I find particularly interesting, and perhaps in doing this I am taking only one part of the concept, what I find really interesting about the dogmatic is the idea that your justification stops, it ends at the dogmatic, it ends with the idea of solidarity. It ends with the idea of dignity in the sense that it is a limit point, which means this, that you don't treat solidarity as valuable because there is another ground. You just treat solidarity as valuable per se. In the same way as dignity. You don't treat dignity because it improves utility or because rational people would agree to it. Yeah. There is no because. There is nowhere to go behind it to find another ground for its justification. Right? So I take this to be questionable. I do take it to be controversial, but I also think it's hugely important in the sense that we can use dignity and solidarity to justify other arrangements, but we don't justify them in terms of other values. We begin with them. So they're limit points because they prevent passage onto a different register. And my own concern always is to prevent passage to a market register. Okay? It's not because it is more efficient. It is not because it maximizes utility. It is because it is in the name of solidarity. It is because it protects dignity. And there's something about the production of value, and this connects a little bit to Marx. There is something about the production of value that is an irreducibly collective endeavor. And because it's irreducibly collective, i.e., it cannot be reduced to the sum of the individual parts, that is why solidarity matters. Solidarity matters because as a society, we share certain risks of existence, we need to pool them, and we need to have institutions to protect them. And this all happens, is my argument, on a collective register that cannot be broken down. If you break it down, you misread it. And of course, social rights, as instruments, as devices to make sense of solidarity in more particular contexts, carry that heritage, okay? They carry this idea that they are not there because they are useful to anything except this collective endeavor, okay? So they're not, and this is important for the rest of my article, individualized actionable rights. They are there because they represent a society's collective response to the risks of existence. Yeah, the people need to have their work protected, their health protected, they should be given shelter, okay, because the society, if it's going to meet the demands of dignity of its members, needs to do that. Okay, that's all about the dogmatic, and we can come back to it. Now, the important bit about social rights is they are middle range institutions. So if solidarity is the ideal, rights are the devices at our disposal to try and meet the demands of that ideal. Okay. And of course, we might have other ways to meet the ideal. The ideal itself is replaceable, but the devices we have to implement it are. My argument in the paper, and it's a little bit convoluted, but my argument is, in a summary, this. I take Thomas Marshall. I apologize for taking an English scholar, but he produced a very important paper after the war. It was actually a lecture. And others have done it too. Habermas has also written about the succession of rights. But what Marshall did is he produced a paper on citizenship and social class, in which he identified a continuity of rights: property and civil rights, political rights, social rights. As I say, this is commonplace. Okay, but what's interesting about what Marshall does is, and this was, remember, just after the war, so there is the aspiration that the war would make the world a better place, is the idea that this would be a way to understand the continuity of rights as a way to overcome class, to overcome the injuries of class society. So there would be something about the protection of citizenship that would protect people against the injuries of class. Now, Marshall has been typically misread because people take from him the continuity argument, but they don't see what's important about it, which is the overcoming. That the one category of rights following another allows a transcendence. This is my main argument. So I start with Marshall and this idea of rights, civil rights, political rights, social rights. Then I take the argument, and then I argue against two different positions. The first position is one that says, look, these categories are not on a continuum, they're discontinuous. You can't treat them as a continuous line. And typically in this kind of thinking, you have an argument called the tragedy of the commons. And in the tragedy of the commons, the main argument is that you have property rights or civil rights in order to correct social rights. Because if you try and meet a society's needs without the corrective of property, you will overfarm, you will destroy the resources of a society. Okay, so the tragedy of the commons is if you go down the route of the commons, you're going to end up in tragedy. You need property rights to control the satisfaction of needs. So quite a right-wing argument. Against this argument, there are four types of continuity arguments. And what is perhaps odd about my paper is I think they're all problematic. So clearly they They are an improvement on the tragedy of the commons, but they are problematic. So the four arguments are the budgetary continuity argument. I'll just mention them, I won't bore you. The justiciability of individual rights argument, the capabilities argument, and the proportionality argument. Now, what these four arguments do and what they have in common is they think that the three categories of rights are continuous. And there is a smooth continuity. You move from one to the other, and they complement each other. So the budgetary continuity argument is famously put forward by two American scholars, Holmes and Sunstein. Is that right? Can't remember. I think that's those two. They say, look, they're all, you know, they all rights involve social costs. Huh? They're all social. They're all social rights because we have to pay for them. You know, if to protect civil rights, you need to have courts, and the society needs to pay for those courts. In order to protect people's property, you have to have a fire brigade. You know, these are costly. In order to run, as you know, in order to have political rights, you have to have really costly elections. Look at how much it's costing you to run this election. Yeah. So say Sunstein and Holmes, all rights are social rights because all involve budgetary resources, and we have to spend money, and then we have to prioritize what we want more and what we want less. So it's a kind of, you know, it's that kind of argument about how sort of, if we are frank about it, we can be moderate about it and not exaggerate the differences. The justiciability argument says, look, they're all justiciable. This is the more problematic argument that really upsets people, to say it's wrong. But if you have a social right, say a right, you're a sufferer of diabetes, and you have a social right to health, it means you can take this claim to a court and ask the court to take action to have your diabetes treatment paid for by the state. Okay. Now, my argument is that that is not what social rights are about. Not because they're not justiciable, of course they're justiciable, but they're not justiciable as individual claims. So your right to education does not mean that you have a right to a place at the university. And your right to health does not mean that you have to have treatment for diabetes. What it does mean is that if clearly there are governmental infringements of these rights, for example, university does not accept women, of course, in the name of the social right to education, you can raise an action in courts, but not as an individual right, okay? We can return to this if you want. The third point is the capacities argument. These are now more demanding arguments. The capacities argument, or the capabilities argument, is an argument that social rights are rights that allow you to participate more fully in the market. So you enhance your participation in the market because you, for example, get the kind of education that makes you competitive. Yeah. So it's a way in which enhancement of market participation is secured typically through social rights. Okay. So social rights are capabilities, are capability building. And the proportionality argument, again, and this is a terrible thing that is developing in the European courts, is the idea that all rights can be pooled together. They are all continuous with each other. And the court is there to balance the one right against the other and to get an optimal balance, whatever that means. Okay? And I state whatever that means because the uses of proportionality have been notorious. Okay, so that's the main, so those are my, and what I end up with at the end of the last part of the argument in the paper is to say there is continuity, but it's not that kind of continuity. It is a continuity that is antinomic. What does this mean? And here I borrow from a Hegelian Marxist argument, is to say that these social rights bring a certain contradiction into legal practice. Because actually to take social rights seriously involves creating a contradiction with the way in which markets allocate value. So there is a way in which this is a different set of priorities that breaks into market thinking in an incongruent way, in a way that doesn't match the way in which markets distribute value, because it upholds certain ideals as non-negotiable. I go back to the dogmatic. And the idea that social rights are about redistribution or about charity or about, if you like, blunting the excessive forms of market behavior misunderstands what they're about. They are not there to compensate at the edges for the operation of markets. They are there producing an independent claim about how resources need to be allocated. And if they are contradictory, we need to insist on that contradiction. And that is where, if you like, because if you insist on that contradiction, the existing economy of representation, the existing distributions, the existing way of making sense of it cannot sustain itself. Okay, so that's the more ambitious side of the argument. And I have certain examples. I don't know if perhaps you had given up before you got there, but if you hadn't, it's the idea that if you hold on to the promise of dignity in situations that, in contexts that deliver indignity, if you hold on to the promise of citizenship in situations that deliver powerlessness, yeah, and if you, for example, insist on the importance of social protection against the claim that it has become unaffordable, then that claim in itself, on the basis of a dogmatic argument, an axiomatic argument about upholding solidarity and dignity, gives you traction, gives you what I call here hermeneutic traction. It makes the suffering meaningful. It makes it something that you can demand that it be alleviated. You see, so that's the point. I can go on about it, but perhaps I'll leave it there. The point is, one about, and this, maybe I'll say this and then I'll stop. There is something hugely interesting in Marxism in terms of how Marx understood the use of contradictions. So typically in Marx's thinking, against the cruder varieties, I think one of the key things that Marx does is to argue that there is a shortfall in the categories available to us to express our full humanity. And he does this typically with the argument about commodity and commodification. He says, we are trapped in a language in which you cannot deliver the full claim of empowerment or emancipation, because you always end up cashing it out in terms of the very categories you want to put in doubt. And I think that is, if you transfer that to social rights, there is something really interesting about a claim that we need to respect people's dignity and solidarity in a way that is not reducible and is not tradable. Okay, I'll leave it there. Thank you.
Excellent. Really, not only interesting, but like provoking remarks. I would ask if someone has a question, if there is some questions coming from our table here, from our virtual audience. If nobody has one, okay, Edvaldo. And then I will also point myself after Edvaldo.
Thank you. Thank you so much, Professor Christodoulidis, for attending our meeting, for sending us the texts, and for your presentation. It was very inspiring, at least the ones I've read. I've read some of your texts before too, and I will make some references here as they come. But first, I would like to say what is the strongest point of the text to me, which is the taking solidarity here to the fore. We, out of curiosity, we have a solidarity as one goal of our republic, that it is on the Constitution, or Article 3 in the Brazilian Constitution. And at least to my knowledge, I haven't read anything on constitutional law that takes this value of solidarity seriously. And I have the feeling that your work gives us a really important step in this direction, which is something I would entitle as a strong point from the text. I have different questions. A lot of them I've made I wrote a lot of remarks. So I'll just try to select some of them. And if we have the time, I will point out others. Some are more of less importance, others are more important, at least to me. So I will start to three comments, questions that perhaps you can react to. The first one is more like a kind of a curiosity from my side. Just in the beginning of your article, you talk about a transition, the transition from Southern European states, from tax states to debt states. Now that's a key point, and it's quite clear. It's just in the beginning on the first page. That is, then you explain what this transition means, that covered the large part of their expenditure through borrowing rather than taxation, and have to service that accumulating debt with an ever-increasing share of their revenue. That's correct. I think we can all have a pretty good idea of how that happened in Europe. But my point is, to what extent could we extend this diagnosis to Latin American countries, for instance? Because as far as I can recollect, at least in Latin American history, Brazilian in particular, we always have been, and if there is anybody here that does not agree with me, you can contradict, of course, we always have been debt states. We always have been debt states, of course, with the different debts of a different nature. At the beginning, from colonialism, most of our independencies, Brazilian independence, that is a quite remarkable example of it, but the dependence came with a cost, which is making debts with the metropolises, be it from Portugal, Spain, or England. That was our case. So we have always been debt states, but of course you were mentioning here another kind of different debt. But even though, if we move forward on time, and if we see Brazilian more recent history, those debts, they were part of the construction of the world national state too. During the dictatorship, for instance, I'm talking about especially the 70s, the 60s and the 70s, most of our industry was built, the national industry was built at the expense of international debts. That is the case of Brasilia, for instance, from the 50s already. Brasilia was built with a huge debt. And my question comes also, the second question comes in this line of reasoning, because these debts, they came from, most of them came from the World Bank and the International Monetary Fund, which are international agencies. So, and that's my second question. If you're talking about Southern European states who are become debt states, to whom belong these debts? Then you can say the market. But if we see it from our perspective here, this market is also physically or geographically kind of located in Europe or in North America. So there is an asymmetry there. And if we talk about debt states, of course, it's a kind of different debt state that we see in Latin America from the ones we see in Southern Europe or in Europe in general. So how would that fit in your diagnosis? How do you react to that? I would say this market rationality of making debts, it hides also, or it encompasses an imperialism or neo-imperialism. There are a lot of labels to attach there, but anyway, that would be my first point. All right. Can I move to the second one, or you would like to stick to it? All right, then let me go to the second point. You have a pretty strong argument in your prolegomena that repeats, that is repeated both in your article and the book, which is the premises or the fundamental premises of social rights constitutionalism. That is, the first one, the social rights, they give institutional form to solidarity. And the second one, this institutional form as constitutional involves constitutive assumptions. I'm reading your paper here, page 4, which are the constitutive assumptions: entrenchment, hierarchy, and rationalization. Correct? Well, as I was reading this fundamental constitutive assumptions, and then on the prolegomenas, the first thing, but that's also because of my research, the first thing that came to my mind is why efficacy or implementation or realization is not a fundamental premise here. It's not a constitutive feature. Then you answer somehow on the chapter from your book, and you have two caveats before moving forward. I'm here on page 244, and you say quite clearly there, whatever the dividends of the recourse to social rights, they will be disciplined to the semantic reach of the implementing rules and the relative inertia of the institutional imagination. And then on the second caveat, you make your argument quite clear. If the processes of constitutional reasoning do not, in fact, allow the smooth passage from the abstract to the concrete and from the general to the particular, this does not mean that the argument about constitutional value, in this case, solidarity, is cancelled in the process of its realization. That was really strong for me. That was really strong, because somehow you're giving an immunity to the constitutional value and an immunity against its realization. If I not understand it correctly, you can of course say otherwise. But my question would be, if we do not consider the realization, the concretization processes by which this constitutional value gains form, wouldn't we be in the face of a pretty clear phenomenon of having a constitutional value that has no relevant significance on everyday life? And if you would like to use more systems theory terms, wouldn't be we dealing with a value, solidarity, and a value that does not orient behavior, orient expectations, and regulates behavior? In other words, it does not it does not become relevant for action or experience in this kind of community in which this value is not minimally or to a minimal degree implemented or realized. And that brings me to another point, which is if we disregard the realization or the implementation, wouldn't we be opening a space for a kind of textualism? Textualism in the sense of taking that constitutional text, which somehow encroaches solidarity as something sufficient for making a rationality to evolve from there. Isn't that a bit difficult to happen or to take place? That will be the second point. Should I move forward to the third one?
Well, shall I try and answer to some of this, and then to give you a breather too? Listen, these are very, very good questions, Edvaldo, and they're very profound, and thank you for reading the text so closely. Okay, when one writes, one writes, as you know, with particular opponents in mind and particular dangers, and sometimes you overstress something in order to protect it from one side and perhaps to make it fallible to another. Let me explain why I go so textualist or formalistic here. It is because in the book I want to protect these values from the kind of creeping constitutionalization that I associate with the market, and the way in which, under the terms constitutional pluralism and ongoing constitutionalization, we lose these fundamental values to a complete banalization, let's say. And then they actually become subject to proportionate weightings, etc. So I want to be textual, if you like. Let me be unapologetically textual and say that formally speaking, these qualities of the Constitution, hierarchy, entrenchment, rationalization, means that these values, which I want to protect because they are dogmatic, cannot have to be placed above their implementation. Okay, above their not to immunize them from them, because if an implementation is at odds with them, then the implementation is problematic, is wrong, is fallible. But what I want to do is hold them up as constitutional values that can be a standard resource. That is why I don't talk about efficiency, implementation, or realization in that bit. At the same time, because you've read the book, there is a great deal discussed about how you move from value to concretization in the language of determinatio, in the language of specification. And the whole idea of rationalization, after all, is holding those levels together. So, you know, a norm that doesn't rationalize the value is a defective norm. Yeah. So a legal norm that doesn't reflect the constitutional value is a deficient norm. So that the process, if you like, of concretization, although at that stage you are in more fallible institutional forms, has to hold to the promise of what it's doing. Now, this may be very old-fashioned and quite convincing, but I'm worried about the way in which constitutional language has been wasted. That's my worry. That if these arguments matter, they should matter and should be protected from the ways in which they are far too often belied in actual practice. I may not have, I'll come back to your first question differently, but that is why why I have this this notion of constitutionality as a formal account, as something that matters because it allows me to protect at an abstract level this. And you're absolutely right. The problem, says Luhmann, with values is they are poorly selective. That is, they don't guide behavior very easily because they can be interpreted in different ways. And that is why if you're going to regulate society, you need to give content to these values through more specific, more concrete norms. Yeah? But the rationalization means that there has to be a connection between the more fallible forms and the. Supiota has a really interesting argument in his inaugural lecture at the Collège de France, which I think is fantastic, where he says, look, the fact that the social state, the welfare state, is today a problematic institution does not mean that solidarity is a problematic thought. It simply means that if we have this institutional form that was particular to the mid and late 20th century has now, under the demands of globalization, become a problem, we need to find alternative institutional forms for solidarity, for the value of the constitutional value of solidarity. So I'm trying to make a similar kind of argument between the levels. Okay. I don't know. The tax and debt states, you're absolutely right there. Okay. And I'd be interested if others have. I don't know how you'd like to do this, Pablo. I see you've got, but if others want to come in on one of these issues, if not, I can try and address your first question too.
Yeah, Evaldo, yeah, I would have a question too, but like it's not that minutious as Evaldo's. But I was wondering that about this antinomy you advanced. I mean, you propose this antinomy between the logics of solidarity, and that would be antagonic or antinomic to the logic of the markets, understood as in a very narrow way, according to the microeconomic theory of the consumer, which is like, yeah, I mean, markets are rational, they are based on very well-defined private property rights and contracts that are that whole theory of the consumer, and I mean the basic theory of the consumer. And I was wondering, because I mean I know your texts, and I know you are acquainted with a whole bunch of literature that actually questions this very understanding of markets that's pretty much limited, and actually it has been under revision also in economics. I mean, also in the discipline of economics, there has been a revision of this dogmatic and pretty much naturalized way to understand markets. And I know that you know the whole new Polanyian theories of markets, that markets actually are also built and constructed, and also private rights, property rights, and individual rights, and property in private property. There's not such a thing as natural property rights or natural individual property. That's something that do not exist at all. I mean, these are these are constitutional creations and political creations that are pretty much, that are actually very, very recent and problematic, because they are plastic and they vary extremely according to political contexts, and that's something I have been thinking since my PhD 10 years ago. Actually, I agree with you that the process of transnationalization lacks to a great extent a political constitution, and the biggest consequence of this fact is that a naturalized way to understand property rights has arisen and established, and they are untouchable. And it's a kind of a middle age, a new feudal structure in which we cannot criticize or politicize some kinds of rights. And I think of one paper especially where I read this argument by you and Goldoni, when you put that bonds, the public bonds, the public debt has become a kind of naturalized kind of property that cannot be discussed politically. And I miss these arguments in your paper and in your presentation too, because in the end, I was reading as if you really buy this whole bullshit that the markets are a natural phenomenon, and since I don't understand the markets as a natural phenomenon, I understand them as a political phenomenon, which are shaped by political decisions. I don't see that big of an antinomy. You know what I mean? There's not an antinomy. It's a political struggle. It's a political struggle. I pretty much prefer your argument that there is an antagonistic potential to discuss understandings, societal understandings of solidarity and property, and that's I would agree, but I don't see this kind of antinomy, because in Marx is an ontological writer. I mean, Marx is still an ontological author. For me, pretty much Marx understood the economy as a ontological structure, which was not political at all, and it shaped the political. And I think that's a problem with Marxism. And actually, the good stuff you propose is actually your post-structural stuff, and not this one. That's my provocation. I mean, I don't see an antinomy. I see a political struggle where there is a very simple argument for a naturalization. There are two things, and I would end my intervention with that. There are two things. There is a depoliticization of markets on the transnational level, putting limits to the political sphere of society, and there is a political argument that plays also within the constitutional playfield, that property should be based on a very narrow conception of individual rights and freedom, and based on these limited under revision theory of the consumer. That's it. And then I like to listen to your response or to your thoughts on that.
Thanks very much, Pablo. Listen, I mean, we'd probably need to be discussing a couple of days to reach because these are very big issues, and I'm not sure I disagree with much of what you say, but perhaps I disagree with why you use this to object to what I've said. So first of all, there's two arguments. There's one argument that was what I presented in the social rights stuff, which is less about markets, where the market is incidental. But you're right that exactly the argument that you were criticizing is made in my book. And my book, The Redress of Law, is about how the language of constitutionalism has been hijacked by markets. So I have, so exactly as you criticized, I have this slightly romanticized idea of the political constitution. And then I say, look, all this stuff has been hijacked by market thinking. And you say, There is no such thing as market thinking. This is to substantialize something that is essentially political, that could be embedded if we go to the Polanyian arguments, or disembedded. Let us look at the whole discussion. I know it's a very European discussion, but the whole discussion of the ordo-liberals were all about this idea of the social market. Yeah, do you know this? So this idea that the social market is an embedded market. It's a market where the state is kept out of it. Okay, so it's not run, the economy isn't run by the state, but the social market is one that delivers and organizes economic activity in a way that is meaningful to people, in a way that might protect ways of life, yeah, that might protect farming, etc. Now, that's not what this is. Perhaps a very European discussion, and I'm not going to go into it, but I see the point, and the point, but what I want to say is that what has happened in fact, there has to be something that we call the market, and what is essential to the market is an idea of circulation. To have circulation, you have to have coinage, yeah, because otherwise you can't circulate unless you have a common denominator, yeah. And property title has a key role to play in this. Now, after that, you have a huge variety of markets. And you may have limited markets and regulated markets, and regulation theorists like Julia Black, who's very, very good, talks about ways in which you can re-socialize the market and not treat it as this horrible abstract mechanism. If you look, though, and this is my argument in the book, if you look at all the virtues that are attributed to the market, you will see that they are there because the market allows you to abstract from embeddedness. Okay, so typically the way this has worked is to first of all say, look, and you could think about Hayek here, huh? You can think about the great theorist of the market. There is an abstract beauty, they say, to the market mechanism, and it has to do with pricing. It has to do with pricing, huh? Because at some point there has to be some reason why we have markets, and the pricing brings the truth that is has even epistemological value, not just political value, not just economic value, but also epistemological value. You know, these are the kinds of activities that our societies value. Why? Because people are willing to pay for them. Yeah, these are market arguments that go all the way to the. Now, if you distill the market to that point where you might say, well, why is it valuable? Because it allows the circulation and the allocation of resources, of value to resources, on the basis of pricing, then you have a problem. You have a problem that it's no longer the political institution that matters, but the abstract, the invisible hand that matters. Now, look, we can discuss this at great length, but what I'm saying is, look, if you take what matters, why it is that the market has become the paradigm of constitutionalism, it is because of these truths. So first of all, you have the collapse of the political economy into the market. So suddenly people are talking about markets and economics as if they're the same thing. Then you have a democratic argument about the market. Look, people put their political preferences, express them through market choices. And then finally, you have the Hayekian stuff. Okay, so let me say, I agree with very much of what you say. On the other hand, what I have tried to track is a very particular form of hijacking of political value, and it's collapsed into a logic of price. And the idea that price carries knowledge or even truth.
Mm-hmm.
And I think that that's where the strong argument is, you know, because Hayek, unlike the other lightweights, Hayek is a very serious thinker.
Mm-hmm.
And he makes these arguments. Huh? Now, so the question might be, well, how much can you build complexity into the market before you lose the beauty of the price mechanism?
But yeah. But I think you say that Hayek was a brilliant thinker, and I agree with that. But he was pretty much aware of the limitations of his thought vis-a-vis politics. He has always been. It's very, I mean, if you read Hayek, it's very, what he proposes as a political constitution, for example, is always an attempt to limit deliberation or to limit the political. And it's very clear, and he confesses it very clearly. It's not a problem for him. He has a very narrow understanding of liberty and freedom and individuality. But even him knows that that price is something that doesn't work just as in the model. That would be my response to. I mean, I think this idea that I think we agree, but like even in economics today, I would contend that the economists in the on the edge scientists in economics, they really believe that the pricing is such a thing as a reality. I think they know that that's a lot of politics there too. I mean, yeah, but I understand that we agree a lot. So let me open for further questions.
I still have a question for it. I have to answer Edvaldo, but I could keep that for later.
Go on.
Okay, so there's a really important point this about colonialism and the tax. So the idea is that you've moved from this is the argument that Streeck makes in Buying Times. He says we've moved from the tax state to the debt state, and so rather than meeting the demands, paying for social protection through taxes, you now pay it through borrowing. We recently had this because I live in a country where the political system is collapsing. We had a prime minister for 6 weeks, Liz Truss, whose main message, repeated ad nauseum, was that we need to move away from tax and spend. She didn't say what to, but clearly what you want to move is to borrow and spend. So what's interesting for social rights constitutionalism in terms of this, and I'll come to your question because it's very important, is this paradox, and it also addresses the budgetary sovereignty people. You know, the people who said, well, it's all budgetary continuities, it's a decision, budgetary decisions about where to allocate resources. There is no budgetary sovereignty. And the whole problem is that the debt state, that in the context of the debt state, the social state that is meant to extend the social protection has to convince financial markets to fund those social services. In order to fund the social services, make itself attractive to the financial markets. And the only way they can make themselves attractive to financial markets is by slashing their welfare budgets. So you have this completely paradoxical situation where in order to fund social protection and social services, you have to slash them to show preparedness for the market. I mean, it happened to Greece, it happened to the whole of Southern Europe. in the financial crisis, we reached levels of paranoia that I think future generations will laugh at, because this made no sense. Now, you're absolutely right. And I'm not just thinking of South America, I'm thinking of Haiti, for example. Think of Haiti and the history of debt there. And these are states completely beholden to the metropolis, completely beholden, to the point at which they are paralyzed. And of course, the whole story that you told quite rightly with the IMF and the structural adjustment programs are, again, political ways of holding people in debt and, in a sense, exploiting them through debt. What's perhaps different is that these political mechanisms, or the direct forms of state capture, have given way to international markets, rating agencies, the whole accolade of all these market players, on the basis of which the credit worthiness or the market preparedness of states is now decided. So I think Europe, this logic has visited Europe in this form typically. And I think that the logic of debt has thereby been generalized. But you're absolutely right that it started off asymmetrically. It started off, I think, through holding states captive through debt. And now this thing has been generalized to include the old colonial powers. I mean, I exaggerate, but I think I don't disagree with you. I think you tell the story correctly, and there is that lovely book by the recently deceased David Graeber, wasn't it? The History of Debt, which is very interesting.
It's a big book.
The first 5,000 years or something. What's it called?
Yeah. I think the first the history of debt, a history the first 5,000 years. So yeah, someone else would like to make a question. Would be really nice. People are shy; they have to speak in English.
Yeah, unfortunately, that's or Greek. I could answer questions in Greek too.
Yeah, I think our Greek is not so good as your Portuguese.
I have a question.
Great.
It's a small question. It's a small question, and maybe it is an abstract one. But do you think that this neoliberal movement and its effects on law, it can change something on the idea that solidarity is some kind of continuity after civil rights, as Marshall said and you wrote in your paper?
Can you ask that again, Lincoln? What was it about social rights particularly?
Yeah.
That you asked?
My question is, do you think that this neoliberal movement and its effects on law, especially in social rights, it can affect this kind of continuity from civil rights and until the social rights? Because as far as I understand the liberal movement, it see that the responsibility of the future of like employee is the responsibility of the employee and not for the circumstance of his life and the social group that he is in. So do you think that this new liberal movement and effects on law can affect the solidarity or affect your argument of the solidarity of social rights?
I think it's a very good question. I think it's a way to lose the argument about solidarity, because you're right. You're right that one of the effects of neoliberal thinking is, for example, to move the responsibility for joblessness to the unemployed who doesn't have the right skills or the right CV for a job. So there is a sense of a moving that responsibility across. The idea then people, you know, I lived this very, very really in my own country during the austerity years, with youth unemployment around 50%, the real sense that one was redundant, and the real sense that there was that it was one's own fault for not being employable. And there is something, I think, particularly disingenuous in terms of that moving of the responsibility across in situations where you have massive increase of wealth. So the idea of, and I say this also in terms of the way in which it can go to I have a particular interest in the organization of work. So in the book, I have quite a lot of stuff about the organization of work, and the move, for example, away from labor-intensive forms of work to capital-intensive forms of work, people being replaced by robots, or people being potentially replaced by robots. So Amazon basically tells you, you know, you can have this job, and if you protest too much, we'll have a robot doing it for you. But there is a real sense of a precariousness that is instilled in the workforce. This idea that you are always potentially redundant. And there is something, again, that about market thinking that removes these from political decisions. Let me give you an example. In France, one of the key issues on which the left campaigned was the idea that for companies that sack their workers and replace them with machines, there had to be, they should pay tax to do that. Now, I'm not saying that's a very effective way of managing it, but you see that there is a political cost or a decision attached to a, you know, a kind of policy, which is a policy. It involves choice. There's nothing inevitable about these things. I think that is a very important point. Also, increasingly, I mean, the one thing, again, it's in the paper too. What's interesting in terms of people who write about rights is how, for example, they might think about certain rights. And I have the example of the freedom of association. Now, there are particular cases in Britain where cases arose before the judiciary that had to decide whether freedom of association meant that someone could decide not to belong to a trade union. Yeah? Or the freedom of association was an individual right to belong or not to belong. And in many contexts, that precise argument desocializes the right of association, okay? Because it no longer is understood in terms of a collective right. A right to associate stops being a collective right, which is paradoxical, to become an individual right. Or the way, sorry, I go on, or the way in which it's connected to action. One of the most protracted deadlocks in the ILO has to do with the employer lobby. You know, the ILO is organized in terms of the tripartite system of labor law. So you have the employer lobby, the employee lobby, and the states, okay? In the same way as labor law is organized. The employer lobby would absolutely refuse to enter into discussions, which completely paralyzed the ILO, until it was conceded that the right of association did not include the right to strike. Okay, because that should be seen as a separate right, nothing to do with association. But if you remove the right to strike, the right to collective action from the right to associate, there's very little you can do as an association. I mean, you can associate, but you can't act on the association. Do you see the point? So these semantic disagreements are hugely important, I think, in terms of how we conceptualize these rights and how we understand solidarity as underlying them. I went a bit far from your question, but these are all political questions that actually translate directly into questions of judicial interpretation.
Yeah, that's fine. I would like to add one thing, and then I think Edvaldo has other questions. I'd like to add that considering when I read texts like this, I always think about Brazilian reality. And yesterday, when I was reading your text, I remember a problem we have here in Brazil about the interpretation of the right of strike here. For instance, we have in our constitution some kind of it's like a general right of strike, and there are some scholars here in Brazil that understand that you can do your strike against some decision of your employer, but also against some decision of the Brazilian parliament, for instance. It's like a political strike. So here we have the Brazilian dogmatic and the Brazilian court's decisions understand that the strike is something that you can only do if is regarding some decision of your employer, and not the kind of, for instance, if we have a new law about labor conditions, you cannot strike against that.
Yeah.
So yeah, we have this this kind of problem here in Brazil because our constitution is some kind of general in the language, and in the reality, the labor dogmatic and labor courts understand that you cannot do your strike against everything, but only against your employer and not against some law discussed in the parliament.
Yeah.
And I'd like to ask.
Yeah. Sorry. Yeah.
Yeah. Just to conclude, and this strike against politics in Brazil is nothing new after the constitution. It's something that the history can show you before our constitution. It's something that really happened before, and so it's not any kind of novelty after the Brazilian constitution. So it's not it's not the problem that the labor courts is surprised to solve. Just to finish my speech here.
Okay. No, I mean, I was just going to say that at least you have a constitution that has mentions the right to strike, whereas in my adopted country, you have no constitution. Yeah.
But no,
Sorry,
may I just add something, because it relates to the matter. We do have a constitution that regulates strike rights, our right to strike, but it also has some prohibitions. There are some categories that cannot strike. For instance, the army or the police. But nonetheless, our state was quite exemplary in this regard. The police went on strike. The police, although the constitution prohibited this kind of strike, and I was there at the time, it was just a terror. So a constitutional right they were advocating, despite the prohibition, gave them this kind of political margin to work, go for a right, an unconstitutional right, I would say, although it sounds a bit crazy. Just in my street,
because the strike, the whole idea of the strike is it has to be disproportionate, and you cannot regulate it, because the whole point about the strike is to show the power of the labor class. But I was just going to add to Linga's point that in Britain, it's not even a constitutional right. There is no right to strike. It's an immunity in private law. So, and there has to be an occupational demand. So there has to be a demand against a specific employer. So you can't you can't engage in a sympathetic strike against your fellow employees. It has to be an occupational demand against a particular employer, and it's only an immunity, which means simply that you won't be sacked for striking. There's no such thing as a right. But these things were really interesting. In the European context, the most disastrous decisions of the European Court in the last 20 years involved the right to strike, and it had to do with the Scandinavian countries. And the European Court decided that there could be no, on a proportionality test, that the right to strike could not outweigh the right of employers or the right of capitalists to move their capital around or to sack their workers. Extraordinary, extraordinary. Sometimes it's called the Lochner decisions of the European Court, because it totally protects private interests against collective rights.
It was that case against involving two unions, one in Finland and one in Letland, or
yeah, one was a
Estland.
Swedish case and one was a Finnish case. So Laval was Swedish,
yeah,
and Viking was Finnish.
Yeah,
and
I read this decision.
yeah, no,
It's terrible.
I would like to make one question, if you may. Actually, it's not about what's written in this text, but I would like to take a few things that you said right now about the role of the Supreme Courts and how they can reassure or be a balance of this problem that you put on your text about capitalism and how these rights are connected or are not actually guaranteed as we expect in these constitutional democracies. So about what Lincoln was saying about strikes and other labor rights that we have in Brazil, the superior courts or even the Supreme Court in Brazil decide sometimes even against what the constitutional rights are saying. For example, recently I was reading about a decision of the Superior Court of the Specialized Justice in Brazil of Labor, that they accept that the employer uses the WhatsApp messages against the employee in a lawsuit if necessary. So it seems to me that's against what these rights are exposed in Constitution. And I would like to know from you, what do you think is the role of the Supreme Courts or superior courts in this sense, if they serve as a balance to this problem, or if they affirm what this capitalism optic is trying to state?
Thank you. That's it's quite a difficult question because it's I mean, a lot of the constitutional discussion that I'm exposed to, or a lot of the discussions I read, are typically about the role of courts. And one of the key distinctions that is used to organize the discussion is between legal constitutionalism and political constitutionalism, whether they should be left as political questions or whether there is a role for the courts in this. It's not something I've written about, and I often think that the way in which people take sides on these questions as a matter of theory is problematic. I think you have to be a lot more pragmatic about it. So, for example, if you're faced with a horrible Tory government like you have in Britain, or you had during, sometimes the courts, even if they are elite institutions, etc., do have a role to play in protecting. This is a roundabout way to say it really depends on the pragmatic conditions. And sometimes, if we can use the courts to protect constitutional values, I think that's a good thing. You know, going back to one of the questions I answered in the beginning from Edvaldo, it was there is an issue. Sometimes they say, well, should certain questions be taken outside politics and be treated in terms of rights, or in terms of textual interpretations, or in terms of immunizing certain things from the rough and tumble of politics? And sometimes the answer is sometimes yes. I know this isn't very satisfactory because I say sometimes, but I really think that with these things, it's not a matter of theory construction. It's a matter of looking at what institutions at certain times are protecting the right things. If you have employment policies where you have this form of intrusion that you describe, perhaps an argument about dignity pursued in constitutional courts is a good thing. I would support it, not because judges are always better placed to answer constitutional questions, because that's just not true, but because in this case, that's where you can defend something that matters. You know, at the moment, for example, in Britain, the Scottish government has gone to the Supreme Court in London to ask whether they have a right to have a referendum in Scotland. That's crazy. I mean, that's a crazy thing to do, to take something as political as an argument about independence and ask judges in London to ask whether there is, whether it falls within the jurisdiction of the Scottish Parliament. It's not a legal question. In these situations, you run the referendum, and if you can get political momentum out of it, you try and force a political decision. But in a case like that, where you mentioned, I think the Constitutional Court has a very good and important role to play.
Well,
but yeah.
Yeah, but I mean, the discussion went to this. I mean, please, yeah. You want to complement something?
No, I was going to say that a lot of these dilemmas were also very, very important in South Africa. And I know less, I fear I know less about Brazil, but I did a lot of work on South Africa. And these questions came before the court all the time, social rights. And the social rights jurisprudence in South Africa is very instructive. The question of shelter, the question of health, the AIDS, the question of water, access to water, these all became big constitutional cases of social rights cases. And the Constitutional Court in South Africa was a very activist court. Initially, it was packed with anti-apartheid activists like Albie Sachs, like Kate O'Regan, you know, extraordinary, Laurie Ackerman. These were extraordinary lawyers, real visionaries. And with some of these questions, they did amazing things. But with some of these questions, they came up against obvious limits. You cannot decide whether someone who needs an expensive treatment in a hospital should have it in a situation where the government are struggling to hold up the health system. Yeah, it's not for Constitutional Court to make these judgments.
And I would like to apologize for taking the discussion to this different subject. I think this text was brilliant, in my opinion, and I'm now beginning my research in post-graduation, and I research constitutional courts. So this role that capitalism play in law is a very challenging thing to put in my research, but it was something I would like to add. And I was trying to take from you some help in this matter. So I'm sorry to
not at all.
deviate the attention from the text.
No, not at all. Thank you, Marcel. And it's a very good question, a very important one. I suppose one of the problems with these discussions is they become polarized too quickly, and people invest too much. And when you invest too much in a polarized discussion, you are not open to looking at the other side. So there is this big move around this idea of juristocracy and the role of constitutional judges and the truth. And the Americans go to town on this stuff. They love it. And on the other hand, you have the kind of the political pro-parliament side. And again, sometimes you think these people are not living in reality. You know, if you look at arguments about the European Parliament, which must be the most anemic, pathetic institution of all parliaments. And then you have these whole theories saying, no, the parliament is what matters and not the court. And you think, well, let's land in reality.
Yeah.
And I see a hand.
Yeah, Edivaldo. I think we still have like 20 minutes, so we could ask if someone has a 10 to up to 20. I have a campaigning also appointment. I will go to do some campaigning for my president. And yeah, Edivaldo.
Yeah, I know when it's a bit late there, so if somebody else has a question, of course, I'm going to give the floor. It's just if there is nobody, then I'll put some easy ones, huh? So we will not stay
easy question. Not as difficult as the first ones.
Yeah, that's a sign of that the text was very inspiring. So I'm just going to put some easy questions, huh? Okay. Just really easy ones. The first one is, there is an expression you used that triggered my attention. In the article, it's on the page 17, which is Dasein der Widersprach. You were quoting here somehow the Hegelian Marxist moment, and you do not give us the source, no, from where you take this expression from. You repeat it on your book, true, on page 252, but I mean, the whole idea is there, it's clear, but the thing is, but the expression Widersprach is the actual word they used, because when I was thinking about it, I thought of Dasein der Widerspruch, contradiction would be Widerspruch. Widersprach is the Präteritum, no? So I'm not sure if you used it intentionally, and if so, why? And as I was reading, I had the sense, but I can be completely wrong, that the expression would be das sei im Widerspruch, that the contradiction, the existence in contradiction, or is this the existence of the contradiction? I mean, it's just I was with some concerns about the expression. If you can clarify it, that would be nice. There is another one, which is also...
Okay, let me just say about that, Edvaldo, you're probably right, and I probably misquoted, but there's the reason why the existence of there is a play there in Hegelian Marxism between the existence of the contradiction and the contradiction as experienced.
Yeah.
Okay. Do you see? So there is, because part of immanent critique is the idea that this is not a logical contradiction, but a real contradiction, to use the Marxist terms. And why is it real? Not because it is real, because it informs an experience of powerlessness on the one hand, but so it's ingrained in the sort of normative experience of someone who feels the contradiction, but is motivated to act on it, you know? So this idea of immanent critique is always a critique. Immanent critique is a critique that spurs people on to action. It's not just it's not just in the field of it's the material relations as opposed to the and that is perhaps, I mean, I'd be very interested if you could actually write to me about the difference between the two, because my German is not very good, but the difference between the two formations. But I suspect that it's trying to capture the existence of the contradiction at both the level of semantics and the level of experience.
Perfect. No, all right.
Maybe we could wrap up if you have a final question. And I would ask, if you have a final question, you can make it, and Emilios could wrap up his contribution to our colloquium.
Yeah, let me ask this one. It will be short, just because I'm teaching hermeneutics this semester, legal hermeneutics. So it popped up to me as an important question to make right now, just to understand the argument better. You say that solidarity it works as an orientation for theological and systematic interpretation. You do this in both the article and the book. And well, I just want to hear what you actually meant by this, because I mean, I was taking the framework of Brazilian Constitution. It is a goal of the Republic, but the theological interpretation, when we carry out this kind of interpretation, we do it in the face of the norm, not of a goal or something that is beyond the semantic scope of the norm. So you're carrying, I'm not saying that solidarity is not important, cannot be taken into consideration for the interpretation, but what I'm asking is, how can we use a theological interpretation in this regard? How would we consider the ends of the norm itself that is being interpreted? And the other is a systematic interpretation, because systematic interpretation, at least in Savigny's traditional sense, that's we take the law as a body, as a corpus. So we cannot separate the norm from the corpus in itself. But why solidarity would function as an orientate, how would solidarity orientate systematic interpretation to this regard? And I would
okay, maybe then I can take this as an opportunity to wrap up. So I think these are very Germanic discussions and distinctions, but I know them because I also was schooled in a Germanic type of legal culture. I take systematic interpretation, the idea to be one about coherence, a way in which the norms hang together, and they hang together through substantive principles that lend coherence to the corpus. So in that sense, solidarity as a value placed high up in the system is one that allows systematic interpretation and therefore a coherence. Teleological, because in any particular case, it would be the value that mobilizes certain interpretative resources that allows you to incline an interpretation in the direction of sustaining solidarity. So there's an overlap between systematic and teleological interpretation, but I think there's slightly difference because the one has its emphasis on coherence and the thing that allows the system to hold together, and the other one on telos. Now, I think that because because this argument is more political than legal, and maybe I could just finish by saying something about critical legal thinking. There is a sense in which what motivates a lot of the analysis is to attempt to pursue certain ideals that are about sustaining collectives, sustaining collective values, sustaining dignity and solidarity, by using, in the best way we can, in a way that doesn't, if you like, abuse or misread the system, read it through the law. And that is why sometimes it sounds overly formalistic, because one of the things that is happening, I fear, is that a lot of our language is being hijacked. And where it has been hijacked and where it used to deliver, we need to hold on to the bits that used to deliver. You know, so there is, in terms of the critical side of this, it is a self-consciously normative argument that has a very particular set of values that it wants to hold on to, but tries to do it through legal means, by, if you like, making the most of the resources of the legal system. And maybe, I mean, we didn't talk very much about critical legal theory or critical legal studies, but I think there's something very important in this term, critical, that we need to perhaps visit again when we find this ourselves together.
Yeah, sure.
But let me also say thank you so much for this opportunity. It was very nice to meet you. And I do hope that we will see each other again soon. And thank you.
Yes, it will be really nice. I hope to see you again, Emilios.
March, no?
Sorry?
March next year. March next year he's coming here.
It's always a pleasure to talk to him. Emilios, thank you so much. It was wonderful. Always very provocative and thoughtful remarks, thoughtful contributions. I would also like to thank everybody that was here today, and the questions were really interesting too. And you can sleep now, Emilios. I know that it's late for you.
I'm okay. Okay, guys, and good luck on Sunday. The whole world is watching.
Yeah. We're gonna do it.
Good.
Bye.
Thank you very much.
Take care. Thank you.
Good night.
Bye.
Ciao, ciao.
Ciao.